Now, I take this prerogative to introduce our guest speaker to you all. Respected Pusarla Bayola Kiran sir is currently working as Assistant Professor of Law in Damodaram Sanjeevaya National Law University since September 2017. He has completed BA LLB Honours, LLM is Business Law, PGTSEIP, UGC NET, APIS SET, and currently pursuing PhD in Law from Dr. B.R. Ambedkar College of Law, Andhra University. He has also worked as an assistant professor of law in Geetam University, Vishakhapatnam from July 2016 to September 2017 and has taught more than 11 different important subjects so far. He holds various different positions at TSNLU, Vishakhapatnam as faculty advisor, Moot and Advocacy Society, member at Center for Business and Commercial Law and Practice, member at Website Development Committee, member at Tender and Purchase Committee. Highlighting some of his academic qualification, Honorable Sir secured first rank in APRCET and in AURCET PhD entrance in 2018 and 2017 respectively, received 7 gold medal in BA LLB honors in different subjects by various renowned authorities, secured region first and state third rank in PGLCET 2014, has a good academic record in undergraduate program of 5 years integrated BA LLB honors as a university topper in 32 papers, received first prize in National Research Article Writing Competition by our own MP Law College, has his articles published in journals of Academy of Juridical Studies, in International Journal of Entrepreneurship and Business Environment, and many more at various national and international platforms. He has he has interned with Indian Institute of Corporate Affairs, Ministry of Corporate Affairs, Government of India, with King and Partridge law firm based in Bengaluru, and with local advocate in Vishakhapatnam. During the academic year from 2017 to 2021, as a faculty member, Honorable Sir has organized more than 10 webinars, various faculty development programs, various workshops, completed various national and international course series, and has delivered lectures at various institutional educational, organized 3 international moot court competition, 15 national moot court competition, various client counseling competition, moot court trials and quiz competitions. Presented 16 research paper at various national and international platforms. He is expert and appreciated for mentoring the moot court teams for various national and international moot court competitions, and has participated in more than 16 various national and international conferences, workshops, and seminars. I heartily welcome you, sir, on the entire fraternity of Manikchand Pahari Law College. Just a little housekeeping before we get started. If you have any doubt, kindly put it in the chat box of your control panel. You all are requested to kindly mute your audio and video modes. Over to you, sir. Please take the charge and enlighten us all.
Thank you so much, Akanksha. That's a very huge introduction, but there's a very small correction. I haven't organized moots or let's say events. I had helped our teams to participate, so that's the only correction, right? Thank you so much. Now, the topic I chose for the day is Hohfeld and the fundamental legal conceptions. So just give me a second. I'll try to share my PowerPoint. Can you confirm whether it's visible or not?
Yes, sir.
Yeah. Thank you so much, sir. So I presume all the students or even some of the teachers had seen this at least during the pandemic, if not in their childhood. So these are things, I mean, at least for me in the early 2000s, this is something which I always wanted to have. So this is a handheld video game. And one of the regular feature of this is the game called Tetris, right? Which runs something like this. We have to make a line complete so that the next thing comes up, and it won't end as long as the screen is not filled. No, so far it's so good, but it seems very simple. But there are a lot of different types of pieces that would come up from the top. So different shapes. So how do we make a horizontal line using all this is the challenge. So I thought that is something meant for kids, but there is something called as a classic Tetris World Championship, and people take it way too seriously. And I think this is 2019 or 2018. The two-time world champion was beaten by a novice. So uh, when asked, he said, "I understand. I try to understand how things flow." And in the commentary, the video is available on YouTube. People say that his idea of looking at things was different. He is looking at the shapes in the proper sense, and he's trying to locate them in a idea that is very peculiar to the champion, right? So with that small understanding, let's deeply dig into what is this Hohfeld's idea, and why this Mr. Hohfeld stands out for his contribution to the analysis of rights. So this is these are the five lines that I had come across in Suri Ratnapala's book Jurisprudence, one of the wonderful textbooks I read so far in this year. So he brings out five statements. He says, number one, I have a right to be paid my wages under the contract of service. I have a right to walk in my yard. I have a right to leave my property to another by will. I have a right not to be arrested without a warrant. I have a right to be respected by my colleagues. Now, the question that comes up when we see this, in all the five sentences, we find the term right. But do we mean the term in the same sense? Are we saying that the meaning of the term right remains same all through in the five sentences? If we put our legal hat, for a common man it may be, but when we put up a legal hat, we are very clear that the fifth one is something that stands out. This has something to do. There is no law which says that one person should be respected by his colleagues. No, there's no law which compels somebody. No, it can be something in a sense that you cannot be defamed, but that's a different story. But we don't have a right to be respected by our colleagues. So we feel when we put that legal hat and say that the fifth sentence is something which is not okay. But since we had studied bit of law here and there, right, we bring in questions like in the first sentence we're talking about labor law, contract law. In the second sentence we're talking about property law. In the third sentence we're talking about succession or all other related laws. And in the fourth sentence we're talking about criminal procedure. But the question that remains is, do we mean the term right in the same sense? Are the impact, or whatever consequences that are associated with these remain same? We are very clear that the first four sentences have something to do with law, but when it comes to identifying or looking at the sense in which the term right has been used, we understand that no, these are used in different meanings, right? Or people say the term right takes color from the context. No, this is not something like maybe class 8 or class 6. We go to the computer lab, open up MS PowerPoint, put up whatever colors we want, and then close it. Computer period is done. We come back. No, we are not talking about that. We are talking about a term which takes color from the context. Now, when we say that a term takes color from the context, we have to be very sure as to in what context are we using this, right? So far so good. Now, what Hoffel did was to bring out the sense that you can't use the same word with different connotations. When you want to mean it in a different idea, you have to use something which suits that, right? Which bring out such proper term. Now, why is it so? I'll come back to these five sentences once I show some extracts from various authors of the textbooks, right? Now, Mark Tibbet, in his Philosophy of Law and Introduction, says the general point of Hohfeldian analysis was that it is wrong to talk about rights when we are seeking to indicate a different kind of legal relation with very different practical implications. Now, going back again, we are using the term right in four different contexts. So, Mark Tibbet says whatever is that Hoffield's two articles put together, I think one is into 61 pages, one is into some 50 odd pages. Now, he gives a wonderful idea here. He says, boss, if you are trying to indicate something different, which has different practical implications, so don't use the term right loosely, right? You can't have it in a broad sense. When you say that right to walk on my yard is different from right to be respected my colleagues, because we said there's nothing law which is looking into it. Similarly, within the law, right to walk on my yard, when you compare with right to bequeath my property, right to transfer or gift my property to somebody, we're talking about different kinds of rights, right? Different kinds of legal relations, to be very specific. Now, it is in that context Hohfield stands out. Now, why is Hohfield looking into all that? Now, I found an interesting tidbit in Suri Ratnapala's book. He says Hohfield studied chemistry before turning into law. And brought to his legal study the chemist instinct of breaking down compounds into their molecules and atoms. So we would have studied in school, if you remember, in chemistry we talk about there are compounds that are made up of different molecules. We talk about water as a compound created out of hydrogen and oxygen atoms. So, and within the atom we talk about protons, neutrons. So as as a student of chemistry, as a chemist, he tried to dig deeper, identify as to what makes things, right? Maybe like if we go back to Tetris, how can you make a line? You can't get all horizontal lines at one go. That is not how the game works. So you find different ideas. Like I had shown, you have an I block, J block, L block. I'll show again. So how do you ensure that they form one horizontal line and that gets disappeared and you get another a line to be filled? So we are looking at what makes, right? Maybe if you compare it to something like the building blocks that you had played in your childhood, you would find different sizes, different colors. From that you would have constructed a house, a car, right? So from the same blocks you would construct different things, right? Now what he is trying to bring up is what are those fundamental things which make our legal relations. Now if we say that there are two people are bound by contract, now when we say contract we are talking about law of contract permitting people to enter into a contract. Wonderful. Now when two people are in contract, we have all those essentials, if you remember, starting with consensus ad idem to maybe something like contingent context. We have a lot of ideas, but one aspect that remains there is both parties have something to do, right? Now I did something from my side as per the contract. I expect the other party to discharge their obligation, or maybe in simpler terms, their duty which flows from the contract. Now, if they have a duty, what do I have? Do I have a right to get that duty done? What is the relationship between right and duty? Right now, if we say right in that context, if we go back to the sentences that we had, I have a right not to be arrested without a warrant. Are we talking about right in the same context? Definitely not. So he is looking at various meanings that are associated to the term right. So he brings in ideas like privilege or claim, power, immunity, and their counterpart. He says each of these has a correlative in the other party. He says something like duty or liability, disability, and in certain contexts, no right. If I have a right, the other party has a duty. Similarly, if I have a privilege, the other party has no right. If I have if I have immunity, the other party is disabled to do something with me. If I have power, the other party is liable to do something, or liable to surrender, or liable to adjust with what is happening there. So he tried to break down things into those fundamental ideas. Now, what is the importance associated with it? Why people are looking at Hohfeld's analysis? Now, Christopher Morris, in his chapter, Some Questions About Rights, in the Routledge Companion to Philosophy of Law, I think this is 2012, he writes two important observations. He says, virtually every account today, referring to the analysis of rights, he says, start with the analysis developed by the American jurist Wesley Newcomb Hohfeld. He distinguished several different elements, anyone or combination of which can be a right in one sense or another, and his distinctions serve as building blocks for virtually all contemporary accounts. Now, I'll take a very simple example. If you had come across the definition of right, you have definitions that range from just a second. I generally suggest the definition of um, Allen, right? He talks about, if you compare Allen's definition with uh, Holland, you have various ideas that flow from the sense that we use the term right. Now, Professor C.K. Allen says a right is a legally guaranteed power to realize an interest. He says a right is a legally guaranteed power to realize an interest. Now, we have power to realize an interest, but what do we mean by this interest? Do you have something to receive? Right? So, you have things called the form of a right and the function of a right. Right? So, over there you have interest theory and the will theory, but both can be explained upon with reference to the Hohfield idea. Now, before digging deeper on Holland's definition of right, let me go back to Allen's definition of right. Let me introduce you Holland's definition of right. He says the capacity residing in one man of controlling with the assent and assistance of the state the actions of others. According to Holland, a right is the capacity residing in one to control the actions of other, and that is not just like that. We are not talking in the nomadic context. I am strong, I control people, right? You went for hunting, you got meat, I am strong, I snatch it away. No, that is not what he is referring to. He says with the assent and assistance of the state, you can control the actions of others. Now, you have a capacity to do so, right? Now, one other wonderful definition of right that comes around whenever we talk about realist school is Oliver Wendell Holmes. He tries to put it in that typical pragmatic practical sense. He says nothing, a right is nothing but a permission. A right is nothing but a permission to exercise certain natural powers, and upon certain conditions obtain protection, restitution, or compensation by the aid of public force. He says a right is nothing but permission to exercise certain natural powers, and upon certain conditions to obtain protection, restitution, and compensation by the aid of public force. Now, so far, so good. We had seen three things. But when we look at the idea, we are looking at things like I have something to do, I have power, right? I can do things, but that has to be done with the assent. I mean, the state should agree to it. I can collect money from people, right? I can demand, but why should people pay to me? Just because I'm strong or I'm elder, can I take it from people? We are talking about the system of law protecting all. Now, if one person is using his power, one person is overpowering others, it is something which is not okay. So in what context such things can be done? In what context you can control actions of others, right? In what context you can do whatever you want is something that is limited to a substantive law. Now, that's again we come back and say that your substantive law defines as to what are your rights, right? How should you behave, or if at all something happens, what can be done? So we talk about the adjective or the procedural law, which helps us in getting our rights done, enforced. So far we are looking at right as a constituent of the legal system. But if we use the term right in that broader sense, something is not okay. We said right can be power, right can be capacity, or right can be some sort of a claim, right? Right can be immunity. Now, let me just go back to those five statements. Now, I have a right to be paid my wages under the contract of service, right? So we're talking about whether it is labor law or contractual law. We are looking at I did my part. Now it has been agreed upon that when I'd worked for those 26 days or 1 month with paid leave or overtime, I stand at a better ground to ask for something. I can claim something. So over here we are saying right, a claim right that is being used in various other versions of jurisprudence that we study today, right? We talk about claim rights as something different from the rights that we have. Maybe whether human rights be considered as claim rights, just because you're human being, can you claim for things? So what are the limitations of it? You have various other things flowing from that. Now, if I am saying that I have a claim, the other party is under some sort of an obligation to honor my claim. So we are saying that they are having some sort of a duty, right? If you have a claim, that the party has a duty. So in a legal relationship, right? In a transaction, in a single transaction, in a legal transaction, if one person has a claim, there is a correlative called duty present in the other person, right? So he says such relationship is the jural correlative relationship or the correlation thesis. A claim brings a correlative of duty in the other party in the same transaction. I had worked and as per my contract of service. So the other party is duty bound to honor the commitment, right? Similarly, I have a right to walk in my yard. Now, we talk about all those comic strips, something like Calvin and Hobbes, or all those sitcoms. We talk about various ideas that come in. This is my house. I live as I want to, right? This is my house. I dress as I want to. Now, don't try doing this at home. Remember, we are living in a place which is meant for all of us. So please don't say that so and so person said we can live as we want in the house. Remember, we have parents and they have been doing certain things for us, and you can't say this is my house, I live what I in a way I want. You don't have anything to say. Now there are limitations to this, so you can't expand or just say stretch Hohfeld to every relationship in the articles that he had written, or whatever analysis that was brought in on the Hohfeldian idea. It said in a legal relationship, in a single transaction, if you say that you have privilege, right? I have a privilege to be like what I want to be. We find all those wonderful status updates on Facebook, Instagram, or WhatsApp. No, you have a privilege. Now, what do we mean when we say that we have a privilege? The other party has no right to question that. It's my privilege, right? So you say that I would love to live in a way I want to, but as I said, don't try to do this at home with your parents. It is highly injurious to health, right? But in a legal relationship, when we say that some party has a privilege in Hohfeldian sense, when it was analyzed at a later point of time, people equated it with liberty. So if you say that if you have liberty to do something in that transaction, the other party has no right to interfere into it. So in the second sentence, I have a right to walk in my yard. You are walking on, let's say, on your terrace. Your neighbor cannot say that, you can't walk on your terrace. Terrace is for all. No, that's your house, right? Your whether even if you're staying on rent, it flows from the idea that you are in possession of it. Even the tenant can't say things like in that transaction. He may come out and say, boss, okay, you had overstayed, we had agreed for 3 years, either pay rent which is double this sum or vacate in 3 months. So that's a different transaction. But in a given legal relationship, in that single transaction, when you say that you have liberty, the other party has no right to interfere, right? They don't have anything to do with it. And particularly, they can't, interfere. It's your liberty. Now, time and again, we talk about laws limiting our liberties. For example, there is this standard idea or quote which goes around, which says, the freedom to swing my fist stops where your nose starts, right? No, I have liberty to swing my fist, right? Maybe can you play cricket at 2 a.m. in the let's say in the night or morning, depending upon which kind of person you are, 2 a.m. in an apartment corridor? I doubt, right? Can you travel on the road without let's say helmet or something of that sort? I own my vehicle, I have liberty to drive it. No, there are limitations over there. We have to look into that idea. He is talking about one legal relationship, right? When it comes to property, maybe I have a right to walk on my property. We are saying that I have liberty to walk on my property. The other party has no right to interfere or limit. They can't limit it. But when we try to look at it from a criminal law point of view, or something like road safety, you have your vehicle, can you drive? Are you at liberty to drive it in any method you want? Definitely not. You can't drive it in one way. So we have to look at Hohfeld's idea in that simple sense, that when you say right in that context, you are saying liberty. You have liberty or privilege. Then the third sentence, I have a right to leave my property to another by will. Now, is it something like liberty? Do I have liberty to do so? We are not saying that this is something akin to liberty. This is something more than that. Do I have capacity? Do I have something called as power? Right? Can somebody stop me? So when you have power, the other party has a disability, right? When you would have studied in succession laws, you have something called as self-acquired property and ancestral property. Limiting just to Hindu law, when it is ancestral property, we bring in the idea of co-personary rights of the co-personers. You have limitations on the surviving co-partner, the topmost generation or the karta, he can't dispose of property as he wants unless there are certain reasons that are to be brought in. But in a given scenario, something that had come from generations above you, you can't be the sole determinant of it. The generations that follow you have some sort of an right in it, or some sort of an limitation on your action. But if you are talking about self-acquired property, I had earned it with the sweat of my brow. Now I can dispose it of, I can gift it to anybody. Now we see all those typical movies which have ideas flowing from typical property related mindset. If one person is walking away with the person he or she likes, the father or the grandfather comes out and says, I won't give you a single penny in my property, right? You won't get a single rupee from the property. So we are talking about all those ideas. He says, this is my hard-earned property, I'll give it to the orphanage. Now he has power. This is not something like ancestral property wherein the son or the grandson or the daughter granddaughter says, no, you can't do it. We are part of the co-personary, we have equal rights. So when you have power to do it, the other party has disability. He says, if you are looking at right, the import of the legal relationship is you are overpowering others, right? You have a better position than others. The others cannot, let's say, uh, disengage you, right? You are entering into some relationship, you have the power over that, the other party is disabled, right? Coming to the last one, the fourth one. Fifth we had already discussed. It is something which is on morality. Should your colleagues respect you? That boils down to morality. We had that idea that we are not talking about law on respect, right? So the fourth, I have right not to be arrested without a warrant. Now, this is something which, if I don't have a disclaimer, turns out to be way too controversial. Depending upon the situation that you are in or I am in, depending upon who's coming to arrest you, you have a lot of other things. But on a general notion, even under CRPC, when we are talking about provisions related to arrest, the arresting officer, whether it is a post amendment or on the basis of DK Basu, they have to show you the warrant. Now, kindly understand, we differentiate between arrest and detention. I'm not talking about detention here, right? Preventive detention. I'm not talking about that. When we are talking about arrest, we are saying that, okay, unless you bring me that uh, some document which authorizes you, you cannot arrest me, right? So till that thing comes, till they have that power, maybe if we go back to the third relationship, power, if they come with a warrant, all you have to do is to show your hands if they are bringing handcuffs. But even on handcuffs, we have enough law to say that if somebody is cooperating, you need not handcuff them, and you need not handcuff them in public, and a lot of other things are there. Now, unless they have power, you're not disabled. Now, if you look at thing before that, if they don't have a warrant, you are having some sort of an immunity, right? So it is in that context, these four sentences try to make us understand the importance of Hohfeld. Now, let me go back to one more extract. Uh, Yeah, this is John Finnis in Oxford Handbook of Jurisprudence and Philosophy of Law. He writes in relation to natural law this wonderful paragraph. The truth is that the concept of right makes little sense, save as maybe if you say Hoffieldian claim right as a correlative to someone else's duty, or as Hoffieldian liberty as protected by someone else's duty of non-interference, or the Hoffieldian power as promoted by the duty of officials or others to recognize and effectuate one's act in law or their ethical counterparts, Or the Hohfeldian immunity is protected by a similar duty of officials and others not to recognize another juridical acts as is purportedly bears on my position. Now, I had very intendedly taken this sentence because I wanted to impress upon the fact that if you don't understand what are the things that make your uh, legal system, right, in a given legal relationship, you have building blocks. Now in this sentence you have right occurring twice, duty occurring four times, right, and you have liberty, power, immunity. Unless you understand these terms, you can never ever understand this sentence in the idea that John Finnis was putting it. Now, that is the seminal contribution of Hohfeld. He said, whenever, going back to Tibet's um, observation, the general point of Hohfeld's analysis was that it is wrong to talk about rights when what we are seeking to indicate is different kind of a legal relation with very different practical implications, right? Now with that idea, let's go back to John Finnis statement, right? This is not on rights, this is John Finnis speaking in relation to natural law, right? He's talking about Aquinas and all other ideas, but this paragraph is something which I picked to show you the importance of using different terms for the term right. Like instead of using those four sentences with right, 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 we have the Hohfeldian substitutes working here. The truth is that the concept of rights make little sense, except in cases like if you're talking about a claim, right? Claim right. What is that claim right? It is a correlative of someone else's duty. Or liberty as protected by someone's duty of non-interference, right? It is what happens indoors is your liberty. Somebody can't peep in, they can't interfere unless we are talking about big boss. That's another different story, right? So we are talking about liberty, which is different in the term that we has used in the second sentence. I have a right to walk on my yard. So over there with the term right, we are indicating the meaning or indicating a relationship of liberty and non-interference or privilege or no right, right? And you have something like power which brings in other parties to surrender, right? They should follow what is to be done in the given scenario. Or immunity, if you have immunity, they can't do things to you, right? So over there we try to use two different ideas in a relationship, right? We said claim, duty, liberty, no right, right? You have all such eight factors that were identified in Hohfeld's idea. Now this is one wonderful book which any law student should read if at all he wants to see as to how jurisprudence operates or how jurisprudence helps you in going ahead, right? William Twenning's general jurisprudence, it is in the globalized context. So while talking about rights on a Hohfeldian analysis, he makes this observation: Hohfeldian analytical scheme has been subject of widespread misunderstanding, different interpretations, criticism, refinements, extension. Questions have been raised about his choice of terms, about particular aspects of the scheme, relationship between two boxes. Now, what are these boxes? I'll show you. Its completeness, its limitations, its utility. Now, remember, these are articles that are written in 1913. Now it's been over 100 years. Now, a lot of people had tried to dig deeper on this, right? So over a period of time, there were a lot of questions that were raised on the Hohfeldian analysis. I think I still have 10 minutes, sir. Can I proceed, sir? I think I still have 10 or 5 minutes. Can you confirm that?
Sir, please proceed.
Yeah, thank you so much, sir. So why are we talking about Hohfeld if these many questions are there in the present day scenario? People criticize Hohfeld's analysis. For example, I said while talking about claims, I said, are human rights claims? Now, in the Hohfeldian language, whenever somebody has a claim, there is a correlative duty. Now, are human rights claims? If so, who has the correlative of such claim, which is a duty? Is it always in the state? Can a private entity violate your human rights? Or is it always the state which has a duty to protect your human rights? Now we have business houses at the UN level. We are talking about business and human rights, the interaction between business and human rights, environment and business. So we have uh, the right duty relationship coming in a very different context than what has been brought in by Hohfeld. Or people talk about, maybe in the Austinian language, absolute duties, duties which may not have related rights to it. He talks about things like duty that is owed to God, or duty to lower creatures, like maybe to animals. So he says these are called as absolute duties. There are no corresponding rights to it. But time and again, things are changing. But one important factor that we need to understand whenever we are trying to dig deeper on Hohfeld's idea is that he's talking about those relationships in a given legal transaction, in that single transaction, right? Now, in a contract, let's say you had entered into a contract to buy uh, spectacles from Lenskart. Who has a duty, who has a right? Is it predefined? Does it remain same throughout the transaction? Let's say, let's count what are the rights we have. If you had ordered something on Lenskart, you want the frame to be as it is seen in the website. Maybe minor color variations, they put a star and say that things may be different depending upon how it is seen, right? Exposure to sunlight, all that. Then you say that you have a right to get proper power for the lens. It should be properly charged so that it serves the purpose. So far so good. So only we have rights, we don't have any duties flowing from this contract. Now, if you look at a very different idea in the same transaction, it flows from the other side. Once we, send you the spectacles, we have a right to get paid, which means to say, as a customer, you have a duty to pay. Now, so far so good. Now let's bring in e-commerce. We are talking about ordering things coming, and it is coming to your home. Now they had packed it carefully, given it to the delivery agent. By the time it reached, it is broken. Do you have a right? Do they have a duty? Now, in such a situation, uh, can they also have a right? Can they sue the delivery agent? Is it a different transaction? So you have to look at those transactions, right? Between two persons, between two entities. If you say that there is a claim, the other party has a duty. You have a correlative. Now, there are other things which come in the later part of Hohfeldian analysis. There is something called as jural opposites or contradictories. People question the language there. Similarly, at a later point of time, various other analysis were brought in on these 8 words. So far, we had seen things like right. Maybe going back to Tetris, you can have the 4-point block which can come down horizontally or vertically. You have privilege. This is called as a J block because it is turned this way. Now, you also have NL block, power. You have an O block, which is immunity, then NS block, uh, then you have a T block, a Z block, and at times a single block makes a lot of sense. Now, why are we looking at all this? Why do you want to understand these terms? Or so far, what am I trying to impress upon? The game of Tetris is challenging, and it can bring in a lot of skills, provided you get to know how to use these 8 to survive, right? And to proceed to the next level. The longer you survive, maybe if you can master how to turn these pieces, you may go and try at this Tetris World Championship. Don't ask me how to enter. I don't know. I just took it as an example. So far, you know how to use these, how to bring in, and when to use and when not to use, where to place. Wonderful. Now you compare that with the concepts, right? The 8 words that we had seen: right, liberty or privilege, power, immunity, duty, disability, liability, no right. If you can look at these concepts, you can use it in all laws. If you are looking at that single transaction, people say, and I agree to it, that Hohfeldian analysis will not work in every situation. But what he tried to do is to impress upon the fact that there are different kinds of legal relationships, right? Uh, uh, like the 4 sentences that we had seen. So, if you can understand the concepts, you can understand law and intricacies that are associated with it in a better sense, right? Now, going back, I said I'll show you those 2 blocks, right? Just a second. I think it's visible. Can somebody confirm whether it's visible or not?
No, sir.
Just a second, sir. I'm trying to share my screen. Yeah. So
Yes,
on
sir.
a basic Google search, you'd find, all you have to do is to type Google Hohfeld scheme of jural relations, or Hohfeld scheme or jural relations. You find different images that are appearing, right? So this is one thing which I'm trying to refer. So they classify it as first order jural relation, second order jural relation. So you have a right, duty, or privilege, no right, power, disability, liability, immunity, and these are interconnected. Now, if I have a right in something, in that same thing, can I have a no right at the same point? It sounds way too stupid, right? So, in one transaction, presence of one type of an action, one type of a concept presumes absence of another, right? You have things called as opposites, uh, contradictories, right? Different languages are used: opposites, negatives, contradictories, depending upon various analysis that are there. But what Hohfeld tried to do is to explain, right, like a basic chemist trying to look at what makes the water molecule. So it is hydrogen and oxygen. What makes a hydrogen molecule? Oxygen's proton, electrons, protons. So he tried to look at those basic elements. So it is in that context, if you are studying jurisprudence or maybe law in general, if you understand this, you stand at a better chance in understanding other aspects of it. So in the ideas that Hohfeld had brought in, you have jural opposites, jural correlatives. I had listed correlatives. You have claim or rights in the stricter sense. The correlative on the other party is duty. Privilege, the other party, no interference. Liberty, no interference. That is no right. Power, liability. Immunity, disability. Now, similarly, you can bring in relationships in the opposite sense. If I have a right, you can't say that I don't have a right, right? So that no right is a very different concept. Maybe we should substitute it with something like absence of right. Now, even in that sense, the sentence turns out to be something which is peculiar. Presence of right in one person issues absence of right in another in the same person. That sounds way too confusing. That's why I don't take that. I take the next one. If you have a privilege, you can say that in that transaction you don't have a duty. It's your liberty, right? You get to be like that. In that sense, you don't have a duty to owe to somebody, right? Somebody doesn't have a right which brings in a duty upon you. You have liberty over there, right? Now, when you have power, this sounds way too easier. When you have power, obviously you're not having disability. So that is the jural opposite he tries to bring in. If you have power in a legal relationship, in that transaction, in that single transaction, you can never have disability. You can't have both concepts in one, right? In the given transaction. Now it can change with transaction changes. For example, you have something like you can walk in a road, right? We said there is immunity, the other party has liability. The moment they get a warrant, right, they get a proper, they are authorized, they are empowered, your immunity turns nothing over there and turns into the other part of the moment they get the warrant, you turn disabled because they are having power. They get a right to arrest. We talk about all those income tax and maybe tax frauds, or for that matter enforcement directorate, money laundering. We have those petitions filed in court which question the power or the right of the investigating agency to arrest. Now, if the court says yes, the CBI or the enforcement directorate has power, simply put, it says the party, the accused, is disabled, right? Now, when you get an anticipatory bail, you can resist an arrest, right? You have some sort of an immunity for that time being, and they should honor that. So the other party which comes in over there, the officer who comes to arrest, if you try to show that the anticipatory bail as a shield, the other party has to respect it. They have that liability flowing there, sorry, disability coming there, and you can't have liability in the same idea, right? Any questions, anyone?
No, sir, there is no question.
Thank you so much, sir. I leave my email ID in the chat box. If anyone has any other concern, I'll be very happy to share.
Sure, sir.
Now, before I leave, I want to share one more idea, or one more appreciation of Hohfeld. There is one article called as Hohfeld's Arc. In that, a paragraph appears wherein Mr. Andrews says, way back in 1900s, Hohfeld had found fire, water, and all other basic elements of law to show as to how the system works. So that is the importance of Hohfeld's analysis. Like we have fire, which changed mankind's future, right? Like the way we eat food, raw meat to cooked meat, right? Water, we use water for various purposes. So these are basic elements that run the society today, that run the mankind today. Now Mark Andrews compares contribution of Hohfeld and says that he found what is fire, water, and all those basic elements for legal relationships that we see today. Thank you so much, sir. I stop it here.
Thank you, sir.
Thank you,
Akanksha?
sir, for yes, sir. Thank you, sir, for such a knowledgeable session. Now, I would like to take this opportunity to propose vote of thanks on the behalf of entire fraternity of Manikchand Pahare Law College. I express my gratitude toward our resource person for today's session, Mr. Pursala Bayola Kiran sir. We believe we are grateful to you for sharing your words, knowledge, and wisdom. We believe the knowledge which you have shared will help us immensely in our future endeavors. We also would like to acknowledge our gratitude to all respective resource person for our for this online series, for nurturing us with their commendable knowledge. For namely Dr. Bhagyashari Deshpande on the topic of analytical theories of jurisprudence for day 1. For day 2, Dr. Arvindranath Tripathi on concepture of jurisprudence for day 2, Dr. Naresh Wagmare on sociological jurisprudence for day 3, Dr. Tejaswini Maligaonkar on American legal realism for day 4, Dr. Vivek Deshpande for natural law theories for day 5. I must mention our deep sense of gratitude to our respected principals, Principal Dr. C.M. Rao sir, to our Vice Principal Professor Shri Kishan More sir, to our IQAC Coordinator Dr. A.N. Kotapalle madam, and to our faculty in charge Dr. Amol Chavan sir. I also thanks to all our teaching and non-teaching staff who has contributed directly and indirectly to make this event a success. At last, I thank all the attendees for being cooperative throughout the session. Also, I would like to inform you that we are going to arrange one more session, for 1 week, that will be on IPC from 4 January to 9 January, and the details has been circulated on all the social media platforms. Also, the recorded version of this whole series will be available at the YouTube channel of our official Manikchand Pahade Law College. Till then, stay tuned and stay safe. Thank you so much, sir.
Thank you, ma'am.
Thank you, sir. Thank you.
It's my pleasure, sir. Thank you so much.
Thank you, sir. Thank you.
Thank you, Kiran sir.